Prior to the start of any residential tenancy in England, it is a legal requirement for landlords or their agents to check that all adult occupiers, not just named tenants, have the legal right to rent that property. It will come as a surprise to many that the right to rent checks also extend to homeowners who rent out part of their property to adult lodgers. You need to conduct right to rent checks on everyone who is occupying your property. If you have engaged the services of a letting agency or property manager, you need to ensure that there is a written agreement in place setting out who is responsible for carrying out the right to rent checks. Failure to comply with these checks will leave you open to civil penalties. It is tempting to think that the easiest route is to rent out your property only to tenants who can produce a British or Irish passport, or to only check the status of those who look or sound like they may not be British or Irish, or to only grant tenancies to tenants with no time limit on their status. That is, tenants who hold indefinite leave to remain or settlement. A word of caution: right to rent checks must be carried out consistently on all adult tenants, regardless of their nationality, race, or any other identifying features. Landlords who discriminate in the way in which right to rent checks are carried out may be subject to a discrimination claim before a tribunal. Anyone who believes that they have been discriminated against, either directly or indirectly by a landlord because of their race or a protected characteristic, may bring a complaint before a tribunal. The Home Office has moved towards establishing a digital database holding the immigration status for non-British and non-Irish citizens residing in the UK. For many migrant tenants holding e-visas or status under the EUSS scheme, their right to rent check can be made online. However, there remains a cohort of migrants who hold immigration documents that cannot be checked online. It is tempting to think that the easiest route is to only accept a tenant whose status can be checked online. You cannot favour the easiest option, and you must provide prospective tenants with other ways in which to prove their immigration status. It is therefore important to consider: do you know what documents to check? Do you know how to check the evidence to be satisfied that the documents appear genuine and establish a statutory defence? Do you know the extent of your responsibilities on when to do the checks and how to record, review, retain and destroy this evidence? In essence, do you have systems in place to ensure that you are complying with your check-in responsibilities before, during and beyond the life of the tenancy? The latest Home Office figures reveal a dramatic acceleration in enforcement, signalling a tougher stance on right to rent checks. The landlord or appointed agent will be liable for any civil penalties for failure to comply under the right to rent scheme unless you can establish a statutory defence. The penalties are significant and can range from £5,000 to £10,000 for each lodger subject to immigration control who is not allowed to rent the property in question. The penalty rises to a range of £10,000 to £20,000 for each occupier. In the most serious cases, a criminal conviction carrying a prison sentence can be imposed. Right to rent compliance is no longer optional. It is essential and should be treated as a core business risk. The Renters' Rights Act has brought an end to no-fault evictions and fixed-term tenancies. Do you know what to do when your tenant's immigration status has changed during the life of the tenancy and they no longer have a legal right to rent?